All right, welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be here till 3 o'clock. We're covering Vermont versus Stephen Bourgoin. Gavel to gavel coverage here at the Law and Crime Network, as always. Okay, welcome back. That's the medical examiner testifying in the Bourgoin case. Okay, and let's have a Law and Crime drum roll, please. Because we have the inimitable, the mentally nimble, the extraordinarily skilled, the Latin-speaking, classic literature-giving, food aficionado, lawyer extraordinaire, Gene Rossi. Welcome, Gene.
You know what? I'm touched that you think I'm a food aficionado because I like polenta.
Yeah, well, you know, listen, I believe a great man once said, hashtag levity is life. Do you know who that is?
You're darn right, and I'm proud of it.
Yeah, that's one of your monikers. Gene, what are you thinking about the case so far? I mean, I know you were listening when I went down the description of what the insanity defense in Vermont looks like, and we listened to a number of clips of some very compelling testimony. I'm just curious, your thoughts on how the case is going, and specifically address for me, Gene, we looked at an MVR, motor vehicle recording, of the cruiser that the defendant was in, and while he was going very fast, estimates up to 100 miles per hour, he was able to maintain the lanes, he wasn't weaving, things of that nature. Is that relevant at all to the insanity defense?
Yes, it is. And Bob, this is similar to that case down in Florida where the flight became a major reason why the individual was found guilty, and they rejected the insanity defense. Now in Florida, as you may have explained, in Florida, it's clear and convincing is the burden on the defense. We now have preponderance, 51%. But I think that flight issue and getting in the cruiser, I think that could be the sine qua non of the prosecution's argument that they haven't met the burden.
No, you didn't, Gene Rossi, whipping out more Latin. I agree. Hey, let me ask you, Gene, because I find this interesting. Now, I could do a deep dive in the legal research of it, but yeah, when Vermont's a little different in the insanity law in that it's not that he couldn't appreciate the rightfulness or wrongfulness of his conduct. Here it says they lack the capacity to conduct themselves, and part of this statute says conform their conduct as required by law. Does that kind of mean that they may have known what they were doing wrong and that they were fleeing, as you suggest, as consciousness of guilt, as we often say, but yet the mental disease or defect prevented them from, quote, conforming their conduct as required by law, that they could find another avenue to get out of this under this insanity law?
Boy, I don't like that statute one bit. Forget the burden. I don't like the wording. The conform to the law, boy, that is a very broad and nebulous and vague word. It gives a lot of leeway for a defense attorney to say, listen, he wasn't able to conform. You know, granted, he took the cruiser, but the mental defect was the main cause, and he couldn't conform. He panicked. He got scared. And I think that's what they're going to say.
Yeah, I mean, that shows you substantially, Gene, as I was trying to explain to the audience before, when you lower the standard to preponderance of the evidence, making it easier, in other words, for the defense to prove its case, and then you add that little caveated part of the insanity law, to your point, you may have been able to appreciate what you did is right or wrong, but you were just compelled by this mental disease or defect not to be able to conform. Boy, that gives the defense a very powerful tool if, in fact, that's the law. But, Gene Rossi, I'm sorry to have you on so quick and go to a break, but we're going to have more Gene Rossi on the other end of the break, so obviously you're not going to go anywhere. We'll be right back. All right, medical examiner testified very quick. Gene, we got a couple things to talk about. Let's talk about the last thing first, and I know we got a real practical debate between me and you, maybe even a difference in trial strategies. But the last point, people were asking in the chat room, like, wow, that's really weird. Why is the prosecutor bringing out information about injuries on the defendant? And you heard me blurt out, seatbelt, seatbelt. I think it's another one of those little facts that shows he was thinking, in addition to the fact that he was preserving his life as he's taking other people's lives. What do you think?
Oh, absolutely. He knows how to conform his conduct to meet the situation. He wanted to save his own life and take the life of somebody else. That's the argument.
Okay, so for all of our legal aficionados out there and those who just love true crime and the gavel-to-gavel coverage they get, Gene Rossi on the Law and Crime Network, and great pros like you, let's talk about this idea, the stipulation. You heard me saying when we were off camera, boy, I rarely stipulate to things. My philosophy, and I think you may have a counter one, is that I have seen stipulations going to a jury, and that is where both sides agree about the parameters of a particular piece of evidence, so it doesn't need to be authenticated. And yet, when the jury comes back, they didn't find in favor of the person entering that item into evidence. I'll give you an example. We have a 1,000-foot law in New Jersey, and before you can prove a 1,000-foot law, some witness has to get up and say, I checked the map created by the city engineer of such and such a city, and it was within 1,000 feet of a school. And there is a map, and it has it very mapped out with circles where that blue areas are within 1,000 feet. I saw a prosecutor have a stipulation to that. It seemed reasonable. It really wasn't a contested fact. And the jury came back and found that it wasn't within 1,000 feet of a school. That's my example.
Well, I can tell you that that was probably jury nullification. Here's my experience on stipulations, and I think we agree. You never stipulate to something that's crucial.
Right.
Where you want a witness to describe it. You never do that. But if it's a stipulation to say venue or chain of custody for the kilo of cocaine, and you have an agent who's a terrible witness, and you want to stipulate to chain of custody that was preserved and sealed and all that, I love stipulations. Right. Okay. Now the second reason is, and this is advanced trial advocacy 4. Your goal as a prosecutor or defense attorney is to bond and connect with the jury, all right?
Bring it home quick, Gene.
Pardon me?
Bring it home quick.
Oh, I love to read the stipulation to the jury because I'm sort of reading the law to them, and I'm almost giving like an opening or closing.
Okay, well, guys, there you have it. The great Gene Rossi and stipulations. We're going to take a quick break, and we'll be right back.